Looks like we are live, so that's good. Uh, Basically, what I wanted to cover was qualified immunity. So basically, back in 1871, Congress passed the what became the Civil Rights Act. Gets muddy. I was asking ChatGPT about it, and was talking about the Force Act or something like that. And um, anyways, I couldn't even find some of the stuff I was looking for. So old. But it doesn't really matter what my opinion is because, I mean, I'm going to be reading the words of an appellate judge in the Fifth Circuit. And so, whatever you think about my capabilities, um, a judge of the Fifth Circuit is just going to know more about it than I do. So, this is a case, and basically, I don't care about the case. Not even about the case, what I want to talk about. So, Mr. Don Willett here concurs with himself, basically, with the his own opinion, to separate his opinion from the rest for this next part. And what's interesting about this is he's not supposed to bring up a new argument at the appellate level, but here it is. Not that I disagree. I don't think the rules are as stringent as they've been made out to be. In fact, they never are. It seems like, one moment Rule 12 is everything, and the next moment it's not. And everything always depends so much about details that it's really whatever you want it to be. Well, not you, but the finder of facts want it to be. Today's decision upholding qualified immunity is compelled by our controlling precedent. See, I disagree. I think there was supposed to be an element of precedent, whereas if there's a new argument, well then you got new standing. It's a new argument, but that apparently is not how it works. I write separately only to highlight newly published scholarship that paints the qualified immunity doctrine as flawed, fundamentally from inception. For more than a half century, the Supreme Court has claimed that 1. Certain common law immunities existed when 1983 was enacted in 1871, and no evidence suggests Congress meant to abrogate these immunities. Abrogate means to set aside, or it's a similar word to abridge, so you divide up. But what if there were such evidence? Indeed, what if the Reconstruction Congress had explicitly stated right there in the original statutory text that it was nullifying all common law defenses against 1983 actions? That is, what if Congress' literal language unequivocally negated the original interpretive premise for qualified immunity? Professor Alexander Reinhardt argues precisely this in this new article, Qualified Immunity Flawed from Foundation, that courts have been construing the wrong version of Section 1983 for virtually its entire legal life. And so these are the the footers. It's like hover over before animation and computers. And so he's talking about this case. And basically, the qualified immunity evolved. It was a common law construct of the court, As passed by the Reconstruction Congress, Section 1 of the Civil Rights Act, now colloquially known as 1983, read this way: any person who, under color of any law, statute, ordinance, regulation, custom, or usage of any state, shall subject or cause to be subjected any person within the jurisdiction of the United States to the deprivation of any rights, privileges, or immunities secured by the Constitution of the United States, shall any such law, statute, ordinance, regulation, custom, or usage of the state to the contrary notwithstanding be liable to the party injured in any action of law, suit in equity, or other proper proceeding for redress. Well, mouthful. Anyways, what he's saying here is if you look up 1983 as written everywhere else, it doesn't say anything about the notwithstanding. There's 16 words missing. And so, oh, that was the wrong. You guys didn't see that, huh? Oh, yeah, you did. Anyways, this is the text that everybody cites. Is all over the legal opinions. This is what it says everywhere, over and over and over again. But what he's saying is, as it was passed, it was actually written this way. The italicized language, the notwithstanding clause, as Professor Reinhardt calls it, explicitly displaces common law defenses. The language that Congress passed makes clear that 1983 claims are viable notwithstanding any such law, statute, ordinance, regulation, custom, or usage of the state to the contrary. The language is unsubtle and categorical, seemingly erasing any need for unwritten gap-filling implications, importations, and incorporations. Rights-violating state actors are liable, period, notwithstanding any state law to the contrary. Then things went off the rails, quickly and stealthily. For reasons lost to history, the critical notwithstanding clause was inexplicably omitted from the first compilation of federal law in 1874. The reviser of federal statutes made an unauthorized alteration to Congress's language, and that error was compounded when the various revised statutes were later published in the first United States Code in 1926. The reviser's error, whether one of omission or commission, has never been corrected. Today, 152 years after Congress enlisted the federal courts to secure Americans' constitutional rights, if one were to Google 42 U.S.C. 1983, the altered version that pops up says nothing about common law defenses. According to Professor Reinhardt, that fateful unexplained omission means the courts and scholars have never grappled with the notwithstanding clause significance. All to say, the Supreme Court's original justification for qualified immunity, that Congress wouldn't have abrogated common law immunities absent explicit language, is faulty because the 1971 Civil Rights Act explicitly included such language. Those 16 lost words, by presumably encompassing state common law principles, undermines the doctrine long uh, professed foundation and underscore that what the 1871 Congress meant for state actors who violate Americans' federal rights is not immunity but liability. Indeed, liability notwithstanding any state law to the contrary. These are game-changing arguments, particularly in the text-centric judicial era when jurists profess unswerving fealty to the words Congress chose. Well, I don't know. I mean, if it's really just the words Congress chose, they can just choose new ones. But anyways, Professor Reinhardt's scholarship supercharges the critique that modern immunity jurisprudence is not just atextual but countertextual. That is, the doctrine does not merely complement the text, it brazenly contradicts it. In arguing that qualified immunity is flawed from the ground up, Professor Reinhardt proposes a provocative question. If legislator enacts a statute but no one bothers to read it, does it still have interpretive force? It seems a tall order to square the modern qualified immunity regimen with Congress's original enacted language. But however seismic the implications of this lost text research, as middle management circuit judges, we cannot overrule the Supreme Court. You're not overruling him. In their opinion, they have a foundation laid for what their opinion is. As soon as that opinion is shown to be inaccurate, then a new opinion is needed. Judge cannot maintain falsehoods. Only that court can definitively grapple with 1983's enacted text and decide whether it means what it says and what, if anything, that means for 1983 immunity. I guess that was it. I think you guys will like these being shorter and sweeter, but I wanted to really highlight this case because this is groundbreaking. All that pain and suffering that police officers, they might have noble intentions, but when you see them acting, let's just say aggressively, and you're not even really sure why, but let me just indicate that when you deal with a certain kind of hassle on a daily basis, like shenanigans of people being taken advantage of, hurt, and you start living in a different world. Your perspective is such that people will kind of get contemptuous with the fact that you're just, disorderly 10,982 or whatever. You're just frequent flyer, or maybe not, but I mean, in general, the car gets used a couple times, day or whatever. I don't know. But when you deal with that kind of stuff all the time, it does have a negative impact on your consideration of others. Like, it's hard to have compassion for shenanigans when that's all you deal with. Anyways, this is very important, and even without this evidence, like I said, Congress can just change this text. But what I'm trying to say is, isn't that what it's supposed to be? I mean, what's the point of saying you have these inalienable rights, right? And if somebody damages you and takes those rights from you, you get compensated with money, which I don't know how that works, but I mean, there's money, there's putting the person who did it in jail, that kind of justice, and that's really all the options people have, when our society has. So when you're talking about trying to solve this problem, whatever. Anyways, I'm out. Rambled long enough.